Welcome to the deep dive. Today, we're going to really tear down a powerful tool in tort law, negligence per se,
Right.
especially if you're dealing with, say, traffic violations, safety regulations. This is kind of a legal shortcut.
Sure.
We'll see how a basic safety rule, like Wisconsin's stop sign statute, WSA 346.46, can actually become the standard for civil liability.
Exactly. It essentially takes the guesswork out of figuring out the duty of care in negligence cases. So for you listening, our mission today is pretty straightforward. First, we'll lay out the key two-part test courts use for negligence per se.
Okay.
Then we'll use a specific case, Totsky v. Riteway bus service, to really dissect that Wisconsin stop sign statute. We'll see how what the legislature intended for road safety turns directly into civil duty.
Yeah, I always find that shift fascinating from, traffic ticket to proving a civil case.
Yeah.
So if someone runs a stop sign, breaks that safety law, how does that specific at that infraction become the proof for duty and breach in a negligence claim?
Well, it's largely about efficiency and respecting what the legislature already decided. Courts figure, look, the legislature passed the safety law. They've already determined what people should do in this situation.
They set the standard.
Precisely. So the general rule of negligence per se says a court will adopt that statute as the standard of care. It establishes duty and breach automatically, essentially, if two specific policy elements are met. It's about legislative intent.
Okay, so we don't need experts arguing about what a reasonable driver would do. The statute just is the standard.
That's the power of it.
So what are those two crucial policy elements? What does the court need to find the legislature intended?
It's purely about what the lawmakers were trying to achieve. First, the plaintiff, the injured person, has to be in the class of persons the statute was actually designed to protect.
Okay, the intended group.
Right. And second, the injury they suffered must be the specific type of harm the statute was aimed at preventing. If you can show the legislature meant to protect that person from that kind of harm, then breaking the statute is negligence. It simplifies things quite a bit for the plaintiff.
That sounds clean, almost formulaic. But applying it is where the details matter, right? Let's use our standard analytical method now with Totsky v. Riteway bus service. So, first things first. What are the legally important facts, specifically regarding the Wisconsin stop sign statute, WSA 346.46?
Sure. The core facts are pretty straightforward. It involved a vehicle operator, the defendant, who approached an intersection with a stop sign. They failed to stop properly or failed to yield the right-of-way as the statute required.
Okay.
And this failure led directly to a collision with the plaintiff's vehicle. The plaintiff was driving on the intersecting road, the one without the stop sign, the through street.
Right, so classic intersection collision after someone missed a stop sign. Given that clear violation, what was the main legal issue for the court?
The precise legal question was, does this specific statute, WSA 346.46, meet those two policy requirements we just talked about? The protected class test and the type of harm test.
Right.
Could the court adopt this statute as the standard of care for civil negligence, meaning the violation itself imposes civil liability?
Okay, makes sense. So what rule of law did the court use to figure that out? Can you state the rule and break down its elements, focusing on that legislative intent piece?
Absolutely. The court applied that standard two-part test for negligence per se. The elements are: 1, was the statute intended to protect a specific class of persons? That's the class of persons test.
Okay.
And 2, was the statute intended to prevent a specific type of injury or harm? That's the type of harm test. Those are the two key questions about legislative intent.
Thank you. That's crystal clear. Now, for the court's elemental analysis, let's walk through it step by step, just like you do on an exam. How did the court apply the first element, that class of persons test?
Okay, so for element 1, the court looked very closely at the exact words in the statute. WSA 346.46, subsection 1, says the driver has to yield the right-of-way to other vehicles which have entered or are approaching the intersection.
Other vehicles.
Exactly. The court zeroed in on that phrase. They found it showed a clear intent by the legislature to protect motorists, the people in those other vehicles on the intersecting road, the ones who are supposed to have the right-of-way. Since the plaintiff in Totsky was driving one of those other vehicles on the through street, the court said, yes, the plaintiff falls squarely within the protected class. Element 1, satisfied.
So it really hinges on that specific statutory language.
Got
it. Now, what about the second element, the type of harm test? How do they analyze that?
Right, element 2. Here, the court asked, why did the legislature put stop signs there in the first place? What harm were they trying to prevent?
Collisions, presumably.
Exactly. The obvious purpose is to manage traffic flow where roads cross and, crucially, to prevent vehicles from crashing into each other. The harm the plaintiff suffered, a vehicle collision, and the injuries that resulted is precisely the kind of consequence the stop sign rule aims to avoid.
Makes sense.
So the court concluded that the statute was intended to protect people from the harm caused by intersection collisions. Therefore, the second element was also met, decisively.
Okay, so both elements checked out based on the statute's language and purpose. After analyzing both, what was the court's final conclusion in the Totsky case?
The court concluded that WSA 346.46, the stop sign statute, did meet all the requirements for negligence per se. Meaning the defendant's violation just proving they ran the stop sign was enough to establish both the duty owed to the plaintiff and the breach of that duty in the civil negligence claim. It gave the plaintiff a very strong path forward.
That really shows the doctrine's power. But here's where, for me, it gets really interesting. It shows just how incredibly specific the law can be. Subsection 2 of that same statute, 346.46, gets into how you must stop. Not just that you stop, but the exact location. What's the hierarchy there? Where does the law say you have to stop?
Yes. The location rules, they are extremely precise. You can't just stop anywhere near the sign. The statute lays out a clear priority order. First choice, the driver must stop immediately before a clearly marked stop line, if one exists.
Okay, stop line first. What if there isn't one?
Good question. If there's no stop line painted on the road, then the driver must stop immediately before entering the crosswalk on the near side of the intersection.
For the crosswalk. Got it. And what about places without either? Maybe a more rural road?
Right. That brings us to the third scenario in the hierarchy, which is about visibility. If there's no stop line and no crosswalk, or, and this is key, if the driver can't efficiently see the intersecting traffic from the stop line or crosswalk position,
Okay.
then they have to proceed cautiously to a point where they can efficiently observe traffic on the intersecting road and stop there. The big takeaway is that stopping, even fully stopping, but in the wrong spot, according to this hierarchy, can still be a statutory violation.
Wow.
And that technical violation can trigger negligence per se.
That's the kicker. A technically incorrect stop is still a breach.
Let's make this concrete with a visceral hypothetical. Let's use subsection 2 meters of the statute, the school crossing rule. Imagine a driver approaches a school crossing. There's an adult crossing guard holding up a sign directing traffic to stop. The driver stops, but stops the car 8 feet away from the crossing itself. Is that a violation that could lead to negligence per se if, tragically, a child gets hit?
Yes, absolutely. Stopping at 8 feet is a violation. It sounds maybe minor, but subsection 2 meters is incredibly specific about distance. It mandates a stop not less than 10 feet nor more than 30 feet from the crossing when directed by a guard.
10 to 30 feet. That's the zone. That's the legally required zone. Stopping at 8 feet is too close. It's a technical breach of the statute. The legislature determined, essentially, that 10 feet is the minimum safe distance there. So, by stopping at 8 feet, the driver has, by definition, breached the standard of care set by the statute, the care designed to protect those kids and the guard.
2 feet. Just 24 inches difference, and it establishes breach of duty. That's strict.
It is extremely strict. It shows the level of precise compliance demanded.
Okay, let's try another one. Subsection 3, the railroad crossing rule. Driver approaches a railroad crossing. There's an official stop sign. They stop exactly 14 feet from the nearest rail. Assume there's no painted stop line. Does stopping at 14 feet violate this statute?
Yes, it does. Another technical violation based purely on distance. Subsection 3 requires a stop not less than 15 feet nor more than 50 feet from the nearest rail if there's no stop line.
15 to 50 feet this time.
Right. So stopping at 14 feet misses that minimum 15-foot safety buffer by just 1 foot. That single foot makes the stop unlawful under the statute. If that violation leads to harm, like a collision with a train, that 1-foot error establishes the breach of duty via negligence per se. It's incredibly precise.
It really underscores how these seemingly simple traffic rules have major civil consequences. Okay, we've seen the general negligence per se test the legislative intent part, and we've seen how specific statutes like 346.46 demand compliance down to the inch, almost. Let's put it all together. What's the actionable step-by-step diagnostic checklist our listeners should use if they spot a statutory violation on an exam?
Okay, here's a framework, synthesizing the Totsky analysis and the specific rules. First step, issue spotting. You've got to precisely identify the statutory violation. Don't just say ran a stop sign. Cite the specific part, like failed to yield per 346.461, or stopped improperly at 8 feet per 346.462 meters. Be specific.
Okay, nail the specific subsection.
Second, Rule application. Clearly state the negligence per se doctrine. Explain that the court adopts the safety statute as the conclusive standard of care, replacing the common law reasonable person standard for duty and breach.
Got it. State the doctrine.
Third, and this is the core analysis, element testing for legislative intent. You have to ask those two key questions from Totsky. 1. Is the plaintiff in the class protected by this specific statute? Think motorists on the through road in Totsky. 2. Is the injury the type of harm the statute aimed to prevent? Think intersection collisions in Totsky.
Test the two intents, class and harm.
Exactly. And fourth, conclusion. If you find both legislative intents are met, protected class, protected harm type, then you conclude that the defendant's violation of the statute conclusively establishes duty and breach, full stop on those two elements.
Okay.
But, and this is crucial, always remember to mention that the plaintiff still needs to prove the other elements. Actual causation and damages. Negligence per se is a shortcut for duty and breach, not the whole case.
Excellent checklist. That really pulls it all together. We started with just, stopping at a stop sign, but through Totsky and the details of WSA 346.46, we've seen the exact legal path for turning even a tiny technical mistake, like being a foot off, into established civil liability for negligence.
It's a powerful illustration of how statutes shape civil duties. And maybe here's a final thought, something for you to chew on. Subsection 4 of that same statute, 346.46, talks about stop signs erected mid-block, not at intersections.
Okay, like in the middle of a long street.
Right. Now, if a driver blows through one of those mid-block stop signs and causes an accident, why might it be harder to satisfy the class of persons test compared to the intersection scenario we saw in Totsky? Think about why a stop sign might be placed mid-block. Intersections are about controlling conflicting traffic flows generally, protecting all approaching motorists. But a mid-block sign, maybe it's only there for a specific pedestrian crossing or a school bus stop or access to one particular factory driveway.
So the protected class might be much narrower.
Potentially, yes. You'd have to really analyze who specifically was the legislature trying to protect with that particular mid-block sign. It might not be all other drivers on the road. It requires a closer look at the specific legislative purpose behind that specific sign's placement. Something to think about.